So have you been to prison before?
No, ma'am.
Do you want to go to prison?
No, ma'am.
Then why are you doing things that are telling the court that you want to go to prison? Not showing up since 2022 is telling me you want to go to prison.
That's not the way.
I'm sorry, what?
I was just trying to stay out the way and
No, because I do compliance hearings to figure out what's going on with people. Because sometimes people, maybe they don't believe me when I say if you have an issue with probation, you can come to court. So I do that, the compliance hearing. So if somebody's sort of tight roping, walking the line, about to fall off into the abyss, which is a motion to revoke and maybe going to prison, I set the compliance hearing so you can come in and you can talk. Court is calling 2019 CR 4354, State of Texas versus Joe Blakey. Can I have parties announced for the record for the state?
Is that done for the state, Your Honor?
Defense,
Brian Kimbrough for Mr. Blakey.
are you Joe Blakey?
yes, ma'am.
I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Joe Blakey who was placed on deferred adjudication in 2019 CR 4354 for the offense of burglary of a habitation force on June 6, 2019 for a period of 4 years? Is that you?
Yes, ma'am.
All right, state.
Your Honor, violated condition number 5 in Bexar County, Texas, the defendant, Joe Blakey, did then and there fail to report to the supervision officer as
Excuse me,
directed,
we're on the record. You may continue.
as directed for a compliance hearing on December 6, 2022 in violation of condition number 5.
How do you plead to that? True or not true?
True.
State,
Your Honor, the state waives and abandons the other.
any
conditions.
No
objections?
objection.
Did you understand by pleading true to violation of condition number 5? That the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, ma'am.
Court will find violation of condition number 5 true. Is there a proposed agreement?
There is not, Your Honor.
All right. Defense, what are you requesting?
Well, Your Honor, we're requesting that you continue Mr. Blakey on probation with whatever conditions the court believes are necessary. He while he was on probation, he did until the end of 2022, I believe, report completed parenting classes, paid over $1,500 in his fees and fines. And while he did have some violations on his, he did do his drug testing, he was using marijuana. So he did have violations for marijuana. In 2022, he moved to Bryan College Station where his mother lives, and he lived there with her and did not report. Now,
Did he have permission to move there?
no, he
No,
didn't.
ma'am.
Okay.
I'll let him explain a little more about that, Your Honor.
Okay.
But I do have some letters on his behalf from his family that I've shown the district attorney that I'd like to present to the court.
Any objection to the court reviewing that?
No, Your Honor.
And I,
You.
Go around.
pardon.
Okay. Let me review this.
Yeah, give me a moment.
All right. Yes.
In addition, Your Honor, he tells me that while he was on probation, he was the operator of a business that he ran called Love of the Land, which was a landscaping and building company, which he hopes to continue to do in the future. And he's an active member of the Mount Olive Missionary Baptist Church.
Mount
And-
Olive located in,
Bryan College Station.
Okay.
However, you were actively a member of an earlier
Do
church.
you want
right?
to call him as a
I
witness?
will call him as a witness.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Joe Blake,
All right, you're gonna need to keep your voice up so that the court reporter can hear and so that I can hear.
Joe Blakey.
All right, defense.
Thank you. And were you a active member of a church earlier?
Yes, yes, sir. I was going to Second Baptist.
Was that here in San Antonio?
Yes, sir.
Now, as I've stated, you did go to Bryan College Station, right?
Yes, sir.
Could you talk to the court a little bit about that and what you did when you got to Bryan College Station, your reason for going there?
Well, the reason why I left is I felt like I was wrongly convicted of an assault case that I didn't even do. And I was still dealing with the
All right, we're here for a burglar of a habitation.
yes, well, yes, ma'am. It's because you ran a concurrent with my probation. I
And
hadn't-
is that a misdemeanor? And I'm just trying to get the record clear. I'm sorry to interrupt. But that assault, is that a misdemeanor assault?
It is. It was a misdemeanor in County Court 13
yes, ma'am.
that I believe the plea was taken after he was placed on
yeah.
probation. I wasn't involved in it.
All right, so I have absolutely nothing to do with that case.
Yes, ma'am.
So the fact that you think you were wrongly convicted of that case, that really doesn't have any weight here because I have absolutely nothing to do with that
Yes, ma'am.
case. I don't even know any of the facts of that case. So let's stick with
Okay.
this case.
Yes,
But
ma'am.
before we go there, could you tell the court what you accomplished and how you felt during the period of time that you were in San Antonio on probation?
Well, when you gave me the 4 years, I told you about my business. I continue doing what you told me to. And I've been doing that. I had left to Bryan because my mom was getting sick and I was not really having too much.
Okay, so you're whispering, she can't hear.
Me and my cousin he was getting money hungry with the business, so I had to stop working with him. I moved on to do the business by myself. I went to Bryan to help my mom out and to just to be better, just to get better.
And while you were there, did you live with your mother?
I stayed with my mom.
Okay.
I still work. I got business. I got a job to do when I get out, if I do ever get out.
If you were to stay on probation,
I don't have no problem being on probation.
right? My question is, if you were to stay on probation,
Yes, sir.
would you want to live in Bryan
Yes,
College
sir.
Station?
Yes,
or-
sir.
Excuse me, stop. So
Yes, ma'am.
here's the thing.
Yes, ma'am.
The court reporter has to take down everything that everyone is saying.
Yes, ma'am.
I want you to internalize what I'm saying right now.
Yes, ma'am.
She has to take down everything that everyone is saying.
Yes, ma'am.
So you need to wait until the question is finished being asked,
Yes, ma'am.
even give it a little pause, and then answer.
Yes, ma'am.
Because when she does her record, and I'm able to view it, when she does her record and your attorney speaks, guess what? She has to put his name down and then say what he said. And then when he finishes, guess what? She has to put your name down and say what you said. So everybody who is on her record is identified by their name. Just think about it for a minute. Judge, and what I'm saying right now, she's typing it in. All right?
Yes, ma'am.
And if you all continue to talk over each other, guess what? She's not going to be able to get it down. I'm not going to be able to concentrate and internalize what you're saying because you all are talking over each other. All right?
Yes, ma'am. I'm sorry, Judge.
Defense.
So, Joe, I want you to tell the judge why you believe that you could succeed on probation if you were given another chance. This is your opportunity.
Because
If you're willing to.
because I was doing good on probation at first. For the first 2 years. I don't have no problem being on probation. I don't smoke weed no more. I stopped smoking in 2022. All I do is work. Go to church every Sunday. Don't do nothing.
Now, you know you made a mistake going to Bryan College Station.
Yes, sir.
You know, you should have talked to your probation and gotten permission.
Yes, sir.
You could have gotten permission,
Yes, sir.
I assume. But while you were there, you were always under the supervision of your mother. Is that correct?
Yes, sir.
And you were not using drugs. Is that correct?
Yes, sir.
And you were working. Is that correct?
Yes, sir.
And you believe you could succeed on probation if given an opportunity.
Yes, sir.
And you have lots of family support in Bryan College Station.
Yes, sir.
Pass away.
You had mentioned your wrongful conviction in a county court 13 case. That was in Bear County, correct?
Yes, sir.
And you were initially granted deferred adjudication, correct?
Yes, sir.
And then you had an MTR, so that was revoked, correct?
Yes, sir.
So in the past, you've shown that you are, when been on probation, you've had it revoked and then adjudicated guilt, correct?
Yes, sir.
No further questions.
All right. So why didn't you tell probation that you needed to go to Bryan College for your mom?
I had stopped reporting before I even left.
Why? Why did you stop reporting?
Well, because of the burglary habitation, I was going through depression mode because I was still dealing with the victim. She wouldn't leave me alone, just holding my kids over me, telling my kids I don't love them, and I was just trying to be for my kids. That's it.
But how are you there for your children if you leave Bear County? Where were your children? Are they in Bear County?
No, ma'am, they with their mom.
And where is that?
They in Houston.
All right, so I don't understand how going to Bryan.
I had to leave the situation. I was trying to get away from her, but she wouldn't let me leave. And I went in a court order saying I couldn't be around her. When I was on house arrest in 2020, she was still coming over to my house, bothering me when I was on house arrest. We had a court order. She would not leave me alone. Just holding my kids over my head, telling my kids I don't love them, I don't want to be around them. And it's not true. My kids don't even want to live with their mom. They want to live with me. That's a whole nother situation.
Okay. Any other questions?
Yeah, just to be clear, so you felt that if you stayed here because she was coming over your place where you were living, you were gonna violate the protective order, or
Exactly.
violate a
I was
condition.
violated with her, but I violated with her coming around me, period. I wasn't supposed to be around her and she wasn't listening.
But you decided to move, but you still didn't let probation know.
Yes, sir.
That was a mistake.
Yes, sir.
Any further questions?
No,
Probation. What are your thoughts on this case? Consider it because it's not on the MTR, but just for the court's knowledge. The assault second, is that allegation in here in Bear County or somewhere else?
it's here, Your Honor.
Okay,
It's in this court.
okay.
I said something.
No
No.
saying.
No, I just wanted to know, I'm not gonna even take that into consideration. The only thing I'm here for is you didn't show up for a compliance hearing. And you're not showing up for a compliance hearing is from December 6th, 2022. So have you been to prison before?
No, ma'am.
Do you want to go to prison?
No, ma'am.
Then why are you doing things that are telling the court that you want to go to prison? Not showing up since 2022 is telling me you want to go to prison. I'm sorry, what?
I was just trying to stay out the way and
No, because I do compliance hearings to figure out what's going on with people. Because sometimes people, maybe they don't believe me when I say if you have an issue with probation, you can come to court. So I do that, the compliance hearing. So if somebody's sort of tightrope and walking the line about to fall off into the abyss, which is a motion to revoke and maybe going to prison, I set the compliance hearing so you can come in and you can talk to me so I can see if we can get you back on track.
yes, ma'am.
And I don't know if you can, I don't know if you should still be on deferred adjudication.
One thing I would bring out, Your Honor, on his behalf is his family support. I've spoken to his mother on many occasions. She tried to be here. I was on trial last week and I think she came down. I had to reset it but she did give me the letters and I've spoken to her and I've spoken to other family members. I understand why he went to Bryan College Station in a sense, because that's where his family is. Now, yes, he definitely broke the rules and he shouldn't have done it the way he did, but I think that's the reason why he went there.
All right, do you want to give me a trial court certification? Because I don't have one here. Trial court certification of defendant's right to appeal.
We're up.
They're on the wall right over there.
Oh, okay.
All right, Mr. Blakely. The only allegation that the state is proceeding on is your violation of condition number 5. Not showing up when the court told you to show up for compliance hearing. I understand that there are some things that you've done. There are other things that you did that were not great. There are things that you've done that have been bad. So I'm going to give you a choice. And the reason why I'm giving you this choice is because globally, I see what's going on with you. I see the issue with the children. I see the issue with the complainant continuing to contact you, even though there's a protective order in place for her not to contact you. I've read the letters from your mom and your family members, and I do remember on this case where we had issues with the GPS, and then the complainant is still contacting him. And the problem with that is, even though the complainant is contacting you, and I know I told you this, you got to pick up the phone and call the police, because if she's contacting you and you allow her in the house, you're in violation. And I understand that maybe you wanted to have contact with her because you're saying she has the children. And I've read the letters in regards to the children. So I'm going to give you a choice. One, you have to be punished because you disappeared on the court. And in this court, there's no reason whatsoever to disappear, right?
Yes.
I will find you guilty, place you on regular probation. So you're going to have a felony conviction. And the reason why you will have that felony conviction is because of you, right? Or I will revoke you and I will sentence you to 2 years in the prison. So those are your choices. You will be, either way, you're going to have a felony conviction. But in one case, you'll have probation. In the other case, it's prison. Do you need to speak with your attorney?
Take probation.
All right. Defense,
That's fine, Your Honor.
state.
Absolutely.
Now, we need to speak about the underlying sentence. I can just give you an underline. I can say, ooh, 10 years underlying. But I want to see if you all can reach an agreement on what you think the underlying sentence should be. Do you all want to discuss that?
We can very briefly discuss it, Your Honor. if
All
that's
right.
okay.
Yes.
No more than a minute or two.
Yes. And I will be the person deciding the length of probation. So don't come to me with an agreement on what y'all think his length of probation should be, because I am 100% going to decide that and not going to consider a length that you are talking about. But the underlying, if you all can see if you can come to an agreement for that.
And Your Honor, just so I better understand, and forgive me if I'm misunderstanding, just in terms of the time horizon. When I initially had opened the NTR, it had noted at the beginning paragraph that the period of deferred was for 4 years, but because it's now community supervision, it's like a new set of underlying.
Yes,
Thank you.
yes.
But this would still be based somewhat on the underlying facts, correct, of the original?
Yes, I mean, you all confer and see if you can come up. All right, so if you'll talk to them, I'm sure they'll give you the police report. So if y'all step out and do that, and I'm going to take a brief break to talk to the jurors outside.
Thank you, Judge.
You're welcome.
Years, Your Honor.
All right, are you asking me to follow that, Mr. Blakely?
It's up to you. It's up to you, Judge.
No, I'm asking you a question and you need to talk so people can hear you.
Yes, ma'am.
Are you asking me to follow that?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right. I'm going to sentence you then to 4 years, and I'm finding you guilty. I'm going to sentence you to 4 years in the prison, suspended and probated for 8 years. There's to be regular reporting by Zoom or in person. Transferred to Bryan, Texas, Was there ever any restitution in this case that was determined? All right. There's to be no contact with Oscar Minor, Minor, Christopher Walker, Charles Walker, $1,800 fine. That'll be probated. And counsel, you stated he completed parenting classes,
He did, Your Honor.
proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. You need to obtain, have you obtained your GED? I'm going to order you. You are either obtaining a GED or either you're going to a trade school. Do you understand?
Yes, ma'am.
Or either some level of higher education. There's to be random, regular UAs. Probation, is there anything else? Anything else you need from the court to be successful?
No, ma'am.
He vanished from probation, stopped reporting, and walked straight into a moment he couldn't escape. The court didn't ask, "Where did you go?" It asked why your actions say you want prison. Letters from family, excuses about stress, promises about church and work. None of it erased one fact. He disappeared when the court ordered him to show up. Then came the ultimatum: probation with a felony conviction, or prison today. No drama, no mercy speech, just reality. Was this accountability, or the last chance before everything collapses? What would you choose? Freedom with strict rules, or a cell? Comment below and like and share for real courtroom moments that hit hard.
There's no question that Mr. Estrada's co-defendant is the person in the video. Everyone can tell that. The people that are identifying Mr. Estrada as being a co-defendant, because there's a mask worn, are two people. In this particular case, and the reason that on 13 they're trying to go forward, there's a clerk, I believe, that says they recognize his eyes. Pretty weak identification. But then there's a stronger identification. The stronger identification is, and I'm sorry, I don't know if it's common law wife, girlfriend, I'm unclear in the status, but significant other. I know you don't like the word baby mama, and I don't think it's the baby mama, so I'm not going to say that.
You mean the mother of his child?
Correct, yes. And I've heard you say that before, and I agree with that. I think it's disrespectful too. So when I say that this case is triable, it's triable on an identity theory. Because of that, our defensive, and I hate giving a defensive strategy, but I have to explain why I need a continuance. Our defensive strategy essentially is that it's not Mr. Estrada, that if his girlfriend comes in and says it's not him or a significant other, whatever it is, we have a fairly weak identification. There's no fingerprints, there's no other information. So the defensive theory is that it's co-defendant's friend, brother, brother-in-law, guy he met somewhere. In other words, this is completely a blame the co-defendant. I don't so much mind saying this is fairly obvious. So I prepared for trial. I have in my pocket a thumb drive with all the information that I have completely reviewed to be prepared to go in front of you today. So two things have happened. The first thing, you've already heard about it, and I'll take last. But the second one is I'm now told that there's some discovery there's being uploaded today. I prepare ahead of time. I am sure that for the state, this discovery is not important. It doesn't go to their theory of the case. Of course, it goes to Mr. Estrada's right to have an effective defense. I do prepare. I want to look at the discovery. I don't know what it is. And I'm not asking for an inordinate amount of time. You bring me back 2, 3, 4 weeks, I'll be ready. Well, I see you shake your head,
No,
no.
not 2, 3, 4 weeks.
Oh, okay.
Mhm.
But what I'm telling you is that I may be, and if you say next week, that's fine. Too. It isn't a question. I want to do the right thing the right way. I want to look at the discovery and judge if it doesn't make a difference. Of course, I'll be ready. If it's earth shattering, it'd be different. Now, there's some other tangential issues that you've already indicated in my motion that are not a proper ground. Fair enough. We can have that.
What would that be?
Well, there's a audio tape where some witnesses say to Mr. Estrada that they came by and served us on a murder. This is an aggravated robbery case. And they say it's not the case you were thinking about. And he says, don't show up on that murder. Now, I think there's a good question whether or not that's wrongful, telling someone not to show up for an different case. That's an issue that I think in the next week I'll be better prepared for, the next 2 weeks or whatever you tell me. And I'll await your ruling on that. And I want to be prepared for that. And I will be prepared for that as well. But the reason I'm asking for time to review the discovery they've uploaded is I know it's not important to them, but I think that a week or whatever you give me is a proper amount of time for us to look at it and me tell you, Judge, I'm ready now or not. Absent the 2 issues, one of which you said is important, but I want to preserve the record. The other that I believe is important, I would be ready today. And I tell you truthfully, as an officer of the court, I've been working for the last 2 weeks. You've seen me in the court. I've asked the court in open court what case was going to be tried. I wanted to be ready today. I respect you, and I want to be ready next week, or if you call me back on Friday, whatever you do. I'm just saying I think it's not allowing me to be effective for Mr. Estrada to ask me to look at discovery last minute that very well may change our theory of the case. Now, do I blame the state? I don't know enough to blame them, but it's a situation we're in, and that's why I'm asking for the limited amount of time that the court would give me.
Judge, so I'll address the forfeiture bar I'm doing first. So Judge, they do talk about a murder case. My understanding is that our investigator did slip of the tongue because there was another murder case on the docket that he did mention murder. But in the phone call, which I don't believe defense counsel had the full opportunity to listen to because they walked away to go talk to their client. Sorry, Diana. That he mentions, regardless, I'm gonna get 25. Don't show up. If you guys show up, they can prove my case. So they know that it's in regard to the cases that we're alleging against him. And he repeatedly says, please don't show up. He talks about the consequences of if they do show up and present testimony in this case, and they aren't here. They were served yesterday. They were served yesterday and were given notice to be here. In regards to the second issue, I did tell Mr. Brobenick that this was information related to the co-defense's cases in the fact that it was evidence specifically linking the co-defendant. I don't believe Mr. Estrada gets brought up in these other cases. I did see that he has a hard drive. I can upload that right now. And it's.
And so you're saying this co-defendant is evidence, the co-defendant's information that you're uploading is evidence that links Mr. Estrada to this case?
No, it links the co-defendant to the case. I don't believe Mr. Estrada is really linked through that evidence. The only evidence that we intended to show was the evidence that's already been that's already been uploaded as of today.
Mhm.
Again, not including the stuff that I've been uploading right now, but previously. This was more of we checked, we wanted to make sure that we had everything in this case because of the co-defendant and because of the the length of investigation. And so that's why we took the time to go and see if there was anything else. I think if Mr. Brobenick takes a look at that other information, there are several other cases that are looked at with the co-defendant in mind, but specifically the one that we're looking at, I can point out and say this evidence was already uploaded.
All right. So you're saying the evidence was already uploaded?
Yes, ma'am. There was significant evidence that was uploaded in this case and the other cases that Mr. Brobenick was already assigned.
All right. And the evidence that was uploaded that you say is already uploaded and you're saying significant, what do you mean by significant?
So it was just all the cases had their own e-discovery, their own e-discovery links. And so it's just each case, it's just more and more evidence for whichever specific case. But when linked together, the evidence that was previously uploaded, that's our case. You know, we're not going into the new stuff. I'm not going to present any of the evidence that was uploaded later.
So the evidence that you're saying was uploaded, has he already had access to it?
Yes, ma'am.
I don't know if I have or not. What I do know is that I am now being placed in a position where I haven't looked at what they're saying. It isn't whether they're going to present it, it's whether it's material to our defense. And I don't know, Judge, but what I do know is that I've prepared by uploading each and everything in the case to this drive. And when there's additional information, I'm very concerned about going forward. It's the whole reason that we signed those discovery acknowledgements, which I cannot sign today.
But what he's saying is that it's already been uploaded. And it wasn't just uploaded today, that you already have it.
Well, everything that is on this drive is what has been uploaded in this case, and I am on notice that we are trying today. I believe that evidence might be to another case, might be somewhere else. But I asked them, and I've been in open court and said it, I want every piece of information on this case. So if they're intending on bringing information from other cases, that was the reason that I went here today and said, what case are we trying? And I want to be prepared on it. On the wrongful by the forfeiture thing, I actually pulled the number of subpoenas that have been done today. I went to the district clerks,
Mhm.
and there's only one subpoena requested on file on this case. I have a copy for the court. It's on Emily Rose Fritz, which is none of these individuals, and there's a return on her. So if there has been a subpoena done, I wasn't on notice of it. Of course, what I would have done is I would have discussed with Mr. Estrada, you can't mess with the witnesses. But I can only prepare him for what is in the records. In other words, there is no record of these people either being a subpoena being requested or issued.
So is your argument that if there are witnesses in a case, unless they're subpoenaed, a defendant can tell a witness, don't show up?
Well, if a person has not been subpoenaed, the law allows you to tell them you don't have to show up.
No, not you don't have to show up, but tell them not to show up. That's what the allegation is, that he told a witness not to show up, not that you don't have to show up. I've been a defense attorney and I know that people have told people, hey, you haven't been subpoenaed, you can show up or not show up. If you've been subpoenaed and you don't show up, one or two things are going to happen. Either the state is going to be like, well, whatever, they didn't show up, or either they're going to want to do an attachment.
So I am returning to what I know to be the law. And the law is that we are entitled to two things. Number one, all the discovery on a case that we've.
I'm talking about the asset,
Yeah.
the forfeiture.
So the forfeiture by wrongdoing,
Mhm.
I do not know whether, because and I have a case here that the standard is that it has to be wrongful, right? And so the question is it wrongful? Well,
The question is it wrongful to tell somebody that they don't have to, that they don't show up to court? Is that wrongful to tell somebody, do not show up to court? If you show up to court, then I'm looking at 25 years. Is that wrong to do?
I believe that is the question. If that is in fact what it said, which of course is the real problem we have here. So what I don't like to do is I don't like to be at the last minute. They're saying it's in some other discovery. I don't know that.
No. I want to talk about this forfeiture by wrongdoing. That's what I want to talk about.
Yes, ma'am.
So let's figure that out. And then we'll come back to this discovery issue.
Okay.
So that's my question. So basically, and I don't know if this is your argument or not. So are you saying that if there's somebody in custody or not in custody on bond, well, no, let's say they're in custody, that to get out of a trial, all they have to do is, if your trial is on, let's say hypothetically, February 6th, You can call somebody on February 5th and tell them not to show. And then the defense attorney can say, excuse me, I need more time. I'm just learning about this. And then let's say hypothetically, that person gets a continuance and their continuance is, let's say it's for March 12th or whatever. I'm just doing a date. And so that defendant knows their court date, their trial is set for March 12th. So they say, you know what? Let me make a phone call. And they make a phone call on March 11th, telling somebody not to show up for court, because if you show up for court, things are not going to go well for me. And then the defense attorney can come in and say, hey, I just learned about this last night. So are we going to do a situation, hypothetically, where defendants are allowed to call people the night before their trial, tell them not to show up for trial, and then everybody gets the continuance because I'm just learning that they told somebody not to show up for trial? And these are just questions I have, Mr. Estrada, and these are hypothetical questions. I'm not saying you did that. I don't know. No evidence has been presented of me, but I'm just trying to figure out everybody's legal thoughts on certain situations.
Judge, I started out a long time ago thinking I knew everything about the law. I have been dispossessed about that idea.
Oh, me too.
The answer is I don't know.
Mhm.
And when I say I don't know, I'm being straightforward and honest with you. I do not know the status of the law. I do not know the status of the subpoenas. I don't know this issue. And this issue popped up at the last moment. And it did pop up at the last moment.
Well, Mr. Brovinick, not to interrupt, but I will tell you, I know the law on that unless it's changed. You know why I know the law on that? Because when I was a prosecutor, and Ms. Ferguson will tell you, on family violence cases, you would think you have a witness, they've been subpoenaed, then all of a sudden they don't show up. You check jail calls, and the night before, whoever the defendant is has called that person and said, do not show up to court. If you don't show up to court, they're going to have to dismiss the case. And you know what I would do? I would play the DVD in court and say, here's your motion. I'm doing an affidavit. I'm doing a forfeiture.
The law
by
didn't
wrongdoing.
change, in fact, since you've been a prosecutor, because I know you've been a judge at least 4 years, right?
Yeah, more than that. But I always try to keep up to date on law. So
Well,
I reviewed it.
so your specific hypothetical was about when you were a prosecutor and you knew the knowledge was from back.
Oh, but here's the thing. I'm telling you that because I have background and forfeiture by wrongdoing, and I always keep up on forfeiture by wrongdoing. And the reason why I do that is because I'm anticipating that usually that happens in family violence cases. So I always check the law every now and then. And then, hey, who knows? Maybe something's changed since yesterday. If it has, I'm willing to be presented with that and keep an open mind on it. I'm always for following the law.
Well, so it has changed since you were a prosecutor, which is where you let me know, and it changed in 2021.
Mhm.
I can't tell you in this specific fact because I've done not a briefing. But you had already indicated to me off the record that you were not going to grant a continuance on this particular
No,
ground.
not on, not because you've got new information that your client allegedly called someone from the jail last night on the 5th. At least that's what's in your motion too. On the 5th, I believe, asking somebody not to appear for trial.
Well, Judge, as you know, when I wrote this, I hadn't listened to the audio tape yet.
Okay.
So it's very difficult for me to make a good legal argument when I have yet to look over the things or read the things, which really brings, since you had already told me you weren't going to grant a continuance on the thing that you are now indicating you're not going to the grounds that you should grant a continuance, which is that I don't know. They're telling me there's new discovery that they don't believe is material. I'm telling the court I don't know. I'm also telling the court I prepared. I'm telling the court I downloaded everything. I'm telling the court that now with this new information under Michael Morton and under the Texas Supreme Court cases, I believe I'm entitled to time to review it. And I'm not asking, I've been a trial lawyer 24 years, which I believe is a little less than you, but I'm not asking for a lot of time. I believe in a week I could be here standing and say, Judge, I'm ready, they were right. Or Judge, we've got an issue. And if there's an issue, I'll come by on Wednesday, Thursday, Friday, as soon as I can. In other words, I'm not going to let it sit out there. But at this point in my career, I am unwilling to take the other side telling me that something is not material to my client's case and is not important.
You're coming back tomorrow for trial. That's the time you have. So whatever he needs to see, he needs to see it.
Yes, Judge.
If he needs to listen to that video, the audio from the jail, he needs to listen to the audio from the jail about
This trial was supposed to start today, but everything stopped when one question changed the room. Did the defendant tell witnesses not to show up? The defense said the case was about weak identification, masks, no fingerprints, no solid proof. But then jail calls surfaced, voices warning, if you show up, they can prove the case. The court didn't argue theory, it asked reality. Can defendants delay justice by silencing witnesses at the last minute? Is that defense or obstruction? With trial set for tomorrow, there were no excuses left. Should the court move forward or give more time? What do you think? Comment below and like and share for more real courtroom moments.